Hi everyone, I'm Niklas. I'm also part of the RIMAD research project. And in this presentation, I want to speak about systemic risk assessment, independent media, and the DSA regulatory framework. I think I'm also going to touch on some of the topics that Ethan has mentioned, like more generally, how now harm is addressed in regulation, and then the challenges that come with defining what that harm really is, especially when dealing with content that is as such but not illegal. And I want to start our conversation by looking at one problem, which I think increasingly becomes important as the DSA is being implemented. And that problem has existed also before we had the DSA, this new European regulation, and that is the problem of evidence. The problem of how you provide evidence that certain content online might actually cause harm. And I have encountered this problem before. I was working for the Oversight Board. And then when working for the Oversight Board, we were asked by Facebook to answer a policy question that they had, which related to what they called the most moderated word on the internet, which was the word shahid, which basically means martyr. And this word was so often moderated because under the dangerous organizations and individual policy that Meta has in place for Facebook and Instagram, to basically praise designated organizations, terrorist organizations, and so forth. And Shahid was often seen as an indicator for this kind of praise. At the same time, Meta was also aware that because they moderate this word so often, they will likely also moderate it in other contexts where it shouldn't be moderated too. And so they pretty much try to figure out, like, what is the right trade-off here? Should we maintain this policy that they pretty much have a blanket ban where Shahid to refer to a designated entity that the content should be removed? Or should they perhaps change the policy somehow? And then what we do at the Oversight Board is we start with an international human rights framework. And based on that international human rights framework, we look at whether a particular restriction that is imposed by a platform is justified or not. And to do that, we build on conventional standards developed for freedom of expression. And that included this test of whether there is an imminent harm linked to the speech. And then when answering this question on how to moderate the word shahid, in the end, we really ran into the problem of assessing evidence of whether the word shahid online contributes to real-world harm or not, and in what instances so. And then we had to figure out how good are actually the automated enforcement systems to recognize context that Meta has, and if they're not recognizing context, and we have to account for also the false enforcement that comes with having a policy such as this one in place. Then, how do we deal with this? And actually, this case led to quite an argument also within the board and within board members, because there were some freedom of expression scholars, and they said, for me, it's pretty obvious that to restrict speech, you need to provide evidence of the harm that it might cause. And then on the other side, there were people saying, well, to prove the harm is always on those who suffer the harm, and otherwise all speech is allowed. Perhaps that's also not really the right solution, because then when in doubt and when no one does the relevant research and has evidence for harm, you will always allow this kind of harm. But I think it also really raised this question of on who is the obligation to find or to develop the kind of research and get the relevant data in order to make evidence-based decisions on what kind of content should be removed or restricted or not. And this problem that I described in the space of human rights responsibilities now increasingly also becomes a problem of compliance in the new regulatory framework. So the new regulatory framework that addresses content moderation is the Digital Services Act in the European Union. And the broad and big idea of systemic risk assessments, which are a key component of the DSA, is that platforms have to what kind of risks are caused through their systems pretty much. So this is a bit of a map of content moderation, and you can see there are many different components. There's the newsfeed, recommendation algorithms, advertisement, enforcement, and so on. And platforms basically have the obligation to assess whether any of these components of their services cause harm. And for this, Article 34 and 35.
I'm listening to the conference, but
and this process pretty much consists in platforms that need to draft the risk assessments themselves. Then they submit them to auditors to evaluate them. They also submit them to the European
my guess is that she
also
works with Andrea.
And as Ethan has also mentioned in this context too, the Commission and the Board for Digital Services, they can develop guidelines and best practices in order to further specify what systemic risk assessments really require.
Yeah.
If we look at what systemic risk assessments are, I think it's helpful to think about it in 3 steps. The first task of a risk assessment is to identify relevant sources of risks. And as I said, these are very broadly defined. It's pretty much anything that has to do with content moderation, including the recommender system, algorithmic system.
He's a communications trainee.
Then you have to identify potential harms that are caused through these systemic risk assessments. And that can, for example, include negative effects for the exercise, but also the freedom and pluralism on the media. And then you have to think about what kind of mitigation measures should you put in place in order to mitigate the harm that you otherwise might cause.
Yeah, perfect. Thanks.
And now that we have this ambitious regulatory framework in place, I would love to think a little bit with you about the kind of challenges that come with it and what kind of we have to develop solutions. Let's look a bit more specifically what it really means to do a risk assessment. So for example, we would have to look at one source of risk, such as the recommender system or any other algorithmic system. Then we have to identify one kind of harm that might be impacted through this source of risk, such as the freedom and pluralism of the media. And then we have to figure out how should algorithmic systems, including their recommender systems, in order to mitigate that harm. And the key problem that we face when now trying to implement these systemic risk assessments is that they are extraordinarily vague obligations. And this is especially problematic because ultimately these obligations relate to the regulation of speech and of freedom of expression. And so now I want to look at different mechanisms that we rely on in order to concretize what these obligations really mean. And I think, as a lawyer at least, I think about in 2 ways. And we can think about substantive solutions or procedural solutions that we can develop in order to further concretize what systemic risk assessments really mean. And one, the law is vague, but we do also have, the government, we have the commission and so forth. So why not let them just provide these guidelines also, as Ethan has mentioned, in the space of misinformation, we already have a code of practice, so why not rely on that? I would make the argument that this is problematic. And why is it problematic? I think it's problematic because really systemic risk assessments have the core objective of protecting fundamental rights of the citizens. That's also what it says. And then if you think about the traditional role, it's really about restricting state interference with the action of privates in order to protect these fundamental rights. If we now say, well, we really empower the European government pretty much through systemic risk assessments and the possibility to concretize what systemic risk assessments mean, to regulate in greater detail the kind of speech that is ultimately allowed, then somehow you use these fundamental rights as an objective in order to empower the executive rather than to restrict them, and everything becomes a little bit confusing somehow. So maybe just giving very broad competencies in order to further specify what systemic risk assessments mean to the executive, to the commission, is perhaps not the right idea. We also have the auditors here in the game in order to review this. I think it's also fairly obvious why they're in order to provide true accountability, because they're ultimately like private firms hired by the platforms in order to audit their risk assessments. So it looks like this procedural solution is not, or this substantive solution by the European Commission going into the substance of what it really means is a bit of a problem. Then we could say, perhaps we should see it a bit more as the task of lawyers. You know, lawyers, we increasingly rely on the positive dimension of fundamental that can guide us somehow into what all of these vague obligations really mean, because ultimately it's about balancing rights and so forth. So perhaps that's also one component of it, but I'm also not very convinced that this is really that helpful, because ultimately there's only so much you can learn from like studying the law and fundamental rights about how you really want to concretize all of this. And so I think there's two other solutions that can help concretizing these obligations. And one is what I refer to as multi-stakeholderism. Basically consists in the question of how do you involve different kind of groups and civil society organizations in the processes of concretizing these obligations. And I also wrote a paper about this called Making Systemic Risk Assessments Work, where I focus on the multi-stakeholder part. But today I want to focus on something else. I want to focus on the role of evidence in the process. I think ultimately what we really can gain from systemic risk assessments is that we provide more resources, evidence-based research that tries to understand the kind of harm that is really caused through different kinds of content. I think the DSA kind of moves the space of content moderation from the space that previously was a matter of corporate social responsibility really into the space of compliance. And the risk, I think, of that is that there was a lot of work also happening or is happening in the content moderation space, not really about the law as such, but it is about understanding causal consequences of what is happening online, trying to develop the right methodologies, collect the relevant data in order to understand what is the real world impact of the kind of systems that are here listed as sources of harms. For example, the design of recommender system and so on. So I think one really key benefit that should come out of these systemic risk assessments, the fact that they are so vague, is that it should motivate us, or it should prompt us, it should show the need of that evidence-based research and contestation is ultimately necessary in order to make any sense out of this and have a better discussion of what should be allowed on platforms and what should not be allowed. In that context, in my last 3 minutes, I would like to speak briefly about some of the work that we have done with the RENET project, which we called MINI, which basically consisted in observing and doing interviews with a few journalists or a few alternative moral media providers and citizens, basically to try and get a better insight into these topics that are also covered by systemic risk assessments, but kind of not start from the law and just look into the law, but more start from the ground up, like the reality that the law is supposed to impact pretty much. And while this was really only like some initial work, a few things that were quite interesting on some of the key topics that are also addressed by systemic risk assessments. One is, for example, about the role of algorithms and how they impact media consumption. So our participants had kind of like an ambivalent, I think, role, an ambivalent position to the algorithms that they know shape what kind of information they see. On the one hand, they viewed it as really being quite necessary and helpful in order to manage the information overflow. On the other hand, understood that this might reinforce some sort of like filter bubbles or so, or that engagement can be like quite arbitrary. And so they saw it like both as something positive on the one side, but then there were also quite serious concerns. What I found quite interesting is that because there's a certain distrust or perhaps annoyance to having to rely on the algorithms, recommendation algorithms of the big platforms in order to basically curate the kind of information that you consume, there is a trend towards trust in individual journalists. So basically that people are increasingly interested in following individual people who then build a personal brand and do their own unique audience engagement, also sometimes outside of platforms, such as through newsletters. So in the end, very old school, like back to the early days of the internet in a way. Want to get it from a trusted source, you don't want to get it through some platform, and so just someone sends out a newsletter and you pay a little bit for that newsletter. Seems to be a business model that is increasingly interesting. And so perhaps if we think about media pluralism and in the context of curation and recommendation algorithms, that's also something that might be somehow part of the picture. At the same time, we also saw quite a lot of trouble and more independent media providers that kind of try to provide alternative channels in order to reach their audience. So yeah, I guess that raised more questions than it answered. And with that, my presentation is also over. Thank you.